Hi, my name's Terzian. I'm the founding attorney here at Inheritance Recovery Attorneys. We specialize in representing individuals with respect to their beneficial interest in their loved ones' estates. We represent clients on a contingency basis. That means we front fees, advance costs, and no fees, no recovery unless we're able to get an economic result for our clients. With that said, I'd like to give a bit of an overview on a specific area of law that we're often focusing on when we're looking to contest, if there's a possibility to contest an estate plan. That's undue influence. Just a quick overview of the other, sort of main areas. There's lack of testamentary capacity. And if you can prove that an individual lacked testamentary capacity to effectuate an estate plan, that would be grounds to invalidate it, to set it aside. It's a tough standard to meet. Even individuals with full-blown Alzheimer's, full-blown dementia are presumed to have moments of lucidity. And so what's in writing, what's signed, what's executed is presumed to be that individual's intent. And so you'd have to show that the individual, failed to understand who their loved ones were, what this estate plan in fact did, and what their assets are. Again, even somebody who has severe dementia is presumed to have these moments of lucidity where they understood, what this estate plan did, what their assets were, and who it was being left to. So tough standard, but that closely relates to undue influence, a person's mental state. So, for example, if medical records show that an individual did suffer from dementia, that would tend to mean that they are vulnerable, that individual is vulnerable to undue influence, vulnerable to, in a sense, the wrongdoing, the manipulation of another. And in this case, let's call that individual the alleged wrongdoer. So again, a typical example, let's take mom towards the end of her life. She does an estate plan, let's call it an amendment to a trust, and that amendment completely changes, the terms of her prior estate plan. So instead of the estate being left equally to her children, it's all left to one individual, one sibling over the other. We're looking for three sort of main areas of evidence, three elements that would allow us to flip the burden of proof to the alleged wrongdoer, so that the wrongdoer then is required to prove that the estate plan was not the product of undue influence. The first is that the individual stands in a position of confidence and trust with the decedent. This is met, where there's a parent-child relationship. So, by virtue of being, daughter or son to the decedent, that is considered a position of confidence, trust. Other examples are if you're a power of attorney for an individual, some sort of fiduciary position. The second sort of area, second element we're looking for, and these aren't in any specific order, but the second element we're looking for tends to be the most difficult to find evidence in, is that the alleged wrongdoer was involved in the so-called procurement of the document, that they, for example, printed the estate plan off of the internet, put it in front of mom, were heavily involved in the terms and the creation of the document. They drove mom to the attorney, found the attorney, we're in the room when the document was signed. They are, their fingerprints, they're involved in the creation of this estate plan. Often difficult to find, especially where an attorney has drafted the estate plan. Because, you know, an attorney that's drafting an estate plan is going to stand by their product, and hopefully if they've, you know, done a good job, a professional job, they would have ensured that this individual was alone, that they weren't being influenced. But, you know, I often find that's not the case. You've often got attorneys that are drafting estate plans where perhaps they shouldn't be. You know, they know that one of the siblings, you know, just only one of them brought mom in, that, you know, they all of their phone calls are with the sibling, and so, you know, there's clear heavy involvement by the alleged wrongdoer. And so a lot of that will come out, you know, in discovery as the case ensues, depositions, subpoenaing of the attorney's file, etc. But again, when you've got an attorney drafting an estate plan, they're going to stand by their product, and that's going to be an important witness who's going to be saying, you know, mom knew exactly what she wanted, I met with her alone, and this estate plan is representative of her intent. So, you know, but tough element, but again, things that evidence that does come out through discovery. Lastly, we're looking for an undue benefit, and that's generally pretty easy to meet, and we generally have that in most of the cases that we're assisting on. And that is that the result is inconsistent with prior estate plans, inconsistent with what you see if it had passed under the laws of intestacy, which is if an individual passes away with an estate plan, and it's called intestacy, it would go to their nearest living heirs equally. Of course, if you've got, a estate plan that leaves everything to one child over the other, that's generally going to be considered an undue benefit. And then it would be up to the alleged wrongdoer to prove that what took place, the estate plan, was not in fact undue, is not in fact the result of undue influence. And that's generally proven with either, videotape, letters, evidence that really shows and explains the rationale and the thought and the process by which the decedent went through to come to this sort of decision as far as the estate plan goes. And so, again, it's a very fact-intensive area of law, and it's a bit of a gray area. It's kind of on a spectrum. Manipulation, for example, is not necessarily illegal. You see manipulation, obviously, as you know, all the time, and it tends to often get rewarded. People get away with it. But as you uncover facts and you start, creating this picture of an individual who was vulnerable mentally, who was reliant on the alleged wrongdoer, where the wrongdoer was involved in the creation of the document, and where, the decedent, didn't seem to have a choice in the matter, that starts looking like undue influence. And so it's kind of this intersection between what we all know and feel is right and wrong and trying to measure it with the law. Although it's certainly an imperfect measure, because, the law rarely measures right and wrong perfectly. It's a court of equity. Probate is a court of equity. It's about fairness. And so, as a case progresses, as you build the facts and get closer to the truth, there comes this opportunity to right the wrong and bring it back to the middle and reach a resolution, whether it's by mediation, settlement, or an evidentiary hearing, a trial. In any event, that's the main area of sort of law that we focus on and often are looking at when we're contesting the validity of an estate plan. And so I hope it was, that's been a generally good overview for you, and hopefully you got something out of it. Please feel free to contact us, request a consultation. Love to see if we can help you. And so talk to you soon. Thank you.